House Judiciary Committee. If you have a cell phone, please put it on silence for us. And want to first of all recognize we've got several judges here overseeing our work today. Some old friends. First of all, Kelly Walk, who's a probate judge from Cobb County. Kelly, stand up so we can see you. There you are. You're relatively new, I know, over there, aren't you? I'm
starting my 7th year.
7th year. Oh gosh, not too. Been a while since I was in your court. All right. Well, thank you for being with us, and Judge Robert Turner, magistrate, who's from down in Houston County. Thank you. And we have 2 of our Superior Court judges, Lawton Stevens from the Western Circuit, and Stan Gunner from Circuit Enola. That's right. So thank you both. Stan used to be down here quite a bit as the head of the Prosecuting Attorneys Council. So we're pleased. Good work you're doing.
I appeared before his father. He scared me badly.
Yep.
Too much better.
Yeah. We've got 5 bills on for today. First thing I'm going to bring up, which is one of my bills, is called, we got one of our fine legislative counsel lawyers here, Betsy Howerton. Betsy, you want to come around and we'll talk about the, fairly quickly, the code bill. Actually, we have 2 of them. House Bill 87, which deals with retirement and pensions, and House Bill 90. We used to have 3 bills, right, Bessie? But with the change of the federal law or the decision taking the Civil Rights Act, Title V out, we no longer have to do a separate election bill.
That's right. So the elections bill is included in the general bill.
Okay.
So House Bill 90 is going to be the general revisor bill that's going to have all the corrections from all the titles except for Title 47, which is in the separate House Bill 87 bill. It goes through, we pay particular attention to the volumes that we're going to be reprinting each year and looking at cleaning up any errors or misprints or anything from those titles. In addition to that, at the end of the bill, Section 54 is the provision that basically reenacts the code as a whole every year. So that's an important provision of that bill. And it's, as you can see, it's lots of details, commas, things like that. If there's any questions about a certain code section, I'd be happy to address it.
We'll take one bill at a time. First, we'll take the House Bill. You talk about House Bill 90 right now, correct? So we're taking that one as a bill, which is the major code revision bill. And let me ask for a motion. Is there a motion?
Do pass.
We have a motion do pass with a second. And discussion on the motion. Anyone have any questions or comments?
No substantive changes. These are all
Good point. The purpose behind the bill is really a editorial changes and not anything substantive being changed. They may find the words either should have been capitalized or it was capitalized, should be not capitalized. Punctuation matters, so all this doing is making those type of corrections.
Yes, yeah, no substantive changes, mostly sort of what we call style corrections for the purposes of
Yes.
the form.
You mentioned about the reenactment clause. What is that section under, Betsy?
In the bill?
Yes, ma'am.
Section 54.
And that's really important because we had a court case where there was some issues about whether that was an enforceable provision, and we at the legislation say yes, it is enforceable, because what we're doing is every year with the corrections we make to the various pieces of code, we also make a full reenactment of what we call the official code of Georgia as published, and that is a matter that needs to be recognized. So we have a motion and a second. Any further discussion? We'll call for the question on House Bill 90. All those in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Betsy, thank you. We'll go to the next bill, which will be House Bill 87.
Okay, so this is the exact same thing except for just the retirement title. So, as you all know, anytime you touch the retirement title, it makes it a retirement bill that you have to get a certification on. So, we have just one change this year. It's just adding dashes. Frankly, it's, I think it helps with when people are doing computer searches, that kind of thing. But it's a very minor change, and that's the only thing in the Title 47 bill.
Thank you. Any questions of Ms. Howerton about House Bill 87?
Move to pass. Second.
Chair calls for a motion.
Move to pass.
Is it seconded?
Second.
All right. Any discussion on the motion? Any questions of the presenter? If not, Chair will call for a vote. All those in favor of House Bill 87 signify by saying aye.
Aye.
Opposed, like sign. Thank you. And we'll let Ms. Howard get back to her other work. Thank you so much.
Thank you.
I think the next one, I know there's going to be some discussion on a couple of the bills. The magistrate bill, which is House Bill 154, I'm going to call for now, and that's a bill. Primary sponsor is Representative Weldon. Chairman Weldon.
Thank you, Mr. Chairman. This is this really just changes one set of numbers from Code Section 1510-2. It just increases the authority of the magistrate court to issue a contempt fine up to $500. Presently, it's $200 is the maximum amount of fine that can be issued by a magistrate court. The probate courts have a $500 contempt jurisdiction, and which just puts parity between the contempt that both courts can issue.
We changed, this was a question, we changed the 200 to 500 in the probate court. Was it last year? 2 years ago? Okay. And so, really to bring parity to these two somewhat similar courts, they both handle from time to time matters of similar nature, somewhat. The request was to also have 500 for the magistrate court. Is that right?
Yes.
Okay. Any questions of the presenter? There are none. Okay. Do we have anyone who would like to speak to House Bill 154? If not, we do have. Come on up, Judge. Please do.
Houston County, I'm the first vice president of the Council of Magistrate Court Judges, and I just want to say we support this. This substantially similar language was passed out of the House last year and got hung up for reasons having nothing to do with the substance of the bill last year in the Senate. So this is just something we've supported to create more uniformity between the classes of courts.
Happens often.
Very true. Well, we appreciate your being with us today, too. Travel up from Houston County.
Well, thank you, and we just ask for your support on this matter.
Thank you, sir. Anyone else care to speak on House Bill 154? If not, we'll close off further public input and comments. Chair will call for a question. For a motion on House Bill 154?
I do pass.
Motion do pass. Been seconded. Any further discussion on the motion? No, we'll call for the question. All in favor of House Bill 154 signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Thank you.
Yes, sir. Representative Reeves, come around, please, sir. We have House Bill 119.
First bill.
Yes, sir. Y'all can't sit together.
He asked me
Yeah,
to come up.
different
I didn't
chair.
just charge up.
That's right. We'll decorum here, please. Mr. Reeves, would you like to present your bill?
Yes, thank you, Mr. Chairman. May it please committee.
I have, again, with me, Mr. Chairman has already introduced her, but Judge Kelly Walk from Cobb County Probate Court. If there's any questions, she may have better answers than I will have on those. I have filed House Bill 119 at the request of the Council of Probate Court Judges and have worked closely with Judge Walk on this. This bill is a small amendment to our evidence code, which will allow a probate judge to more efficiently handle what's called an OTA, which is an order to apprehend, which involves specifically persons with HIV or AIDS. Just quick background, Title 37 in our mental health code deals with voluntary to involuntary commitments for persons who pose a harm to themselves or others, and specifically this power that probate court judges have comes from 37-3-41. When a person who poses a harm to themselves or others is identified, the hope and goal is to get them in the custody of a doctor or physician who can evaluate them and see what help they need. There are multiple ways a person who fits in that category can be brought into medical attention or custody to receive this evaluation. One way is by an order to apprehend signed by a probate court judge. It's a frequent process, happens weekly, sometimes daily. However, if the subject indicates, or if it's indicated in the process that they have HIV or AIDS, it triggers another process in Title 24, which takes approximately 5 to 7 days to complete. That lapse of time to complete the Title 24 process frustrates the very purpose of the authority that our probate judges have here, and that's to get someone immediate help. The need here is to act immediately. It's critical. And this OTA, order to apprehend process, is simply a protection offered to our citizens who are mentally ill. The protection needs to be made available to all persons, whether they have HIV or AIDS or not. Superior Court judges have already have an exception to this Title 24 process. We, in our bill, have mirrored the language that they have used, except for we have very narrowly used it just to identify this one particular statute that the probate court judges use when they sign these OTAs.
All right, thank you. And Judge, you'd like to comment on your bill?
Simply
Pull
to
your mic around right
yes,
there.
Sir.
We've got millions of people watching us worldwide.
Simply to say that this is a recurring issue, not a frequent issue. It's very narrowly tailored. We are trying to sort of hunker down on who we're disclosing to, not to do anything to increase disclosure and to make the process more efficient. And we just ask your support. And I'm here for any questions that anybody has.
Thank you, Judge. Do we have any members of the committee wish to ask questions of the presenter or Judge Walk? I see none. All right. Thank you for your coming forward to testify, and we'll have Catherine Fitch, I think, is also wanting to speak on the bill.
I just want to say I'm Catherine Fitch on behalf of the Judicial Council and Administrative Office of the Court. This bill and our last bill that you just heard, they're part of our legislative package. They both passed unanimously through Judicial Council, and we would ask for the committee's support. Thank you.
Thank you, Ms. Fitch. Anyone else in the audience wish to address House Bill 119? If not, we'll close all further public input. The bill is now in the breast of the committee. Do we have a motion?
Second.
Moved and seconded, do pass. Do we have discussion on the motion? Yes, sir. Mr. Weldon.
Thank you, Mr. Chairman. And anyone on the committee, or if the chairman so otherwise, I'm just trying to think of the fact, or at least a couple of fact patterns where this is necessary. And the one I'm thinking of is when you have an incapacitated adult that has this situation of mental illness that results in that incapacity. I mean, that's
So
the
true.
primary consideration of it. So.
I would agree with you. And who's? Ms. Oliver, thank you.
I see the 1013 process as an emergency, a psychotic episode where someone needs an evaluation, not a commitment, but an evaluation. That's what the 1013 is. And I checked with my probate judge on this because of a large county with a lot of psychiatric facilities. And she says this comes up a half dozen times a year, and it will delay the process of sending out the order for evaluation for many days, if not a week, which is just not helpful in an emergency situation of somebody in the midst of a psychotic episode of some kind.
And if I may, Mr. Chairman.
Yes, sir.
This, as the the baby boom population ages, the Alzheimer's and dementia, is that something that was used? This is used more?
I think, in my experience, as it's described to me and as I've seen in the probate court, it's used more for emergency erratic behavior that's inconsistent with somebody. An older person who has sort of increasing dementia, it could be used for those situations where they're suddenly discovered. Their behavior is suddenly presented to somebody else that they had been perhaps hidden before.
Thank you.
Mr. Welch?
Thank you, Mr. Chairman. The question I had was, I don't know of a circumstance, I don't understand the language on line 21 that says, or any other public or private need. You said compelling needs force away the public health, safety, welfare need. Why is the language or any other public or private need? What is that about?
Here's the language that's in the Superior Court, if you look at line 31.
That's the existing language.
That's correct. The idea was to bring it
Yeah.
from the Superior Court into the Probate Court. If there's any case law that's generated from that, then they can have something to rely on.
Anything further, Ms. Welch? Yes, sir. Did you have Ms. Fleming? All right. Any further discussion, comments? If not, the chair will call the question. Question is a favorable vote for House Bill 119. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries for approval of House Bill 119. There was not any changes made in any of these bills in committee, subcommittees, whether I think they're all as presented, right?
Except for HB 90, the general revised bill.
The general revised bill, that's right. We did have a change on House Bill 9, so we have a committee substitute going forward as to the revised bill, which is an unusual thing, I might add. That we usually don't have to do that with a revised bill, but in this case. Chairman Fleming, I'm going to turn the meeting over to you at this point, if I might, as I will be the presenter of the next bill, which is House Bill 59. If you would preside, please, sir.
Absolutely. We have before us now House Bill 59, and Mr. Chairman, if you would go ahead and present your bill, we'd appreciate it.
I appreciate it, too. I'm going to remain in my chair, if I might. To give you some background, the bill itself deals with the issue of sovereign immunity. And I got to find the bill, lost it. I got to put it under here. Okay. I got it. It's a one-page bill. But let me give you some, first of all, background and history. Why is the bill being brought? We had a decision of the Georgia Supreme Court last February, and that decision is Georgia Department of Natural Resources et al. Versus Center for a Sustainable Coast. And by that decision, which was fairly lengthy, the Supreme Court recognized the constitutional provisions that first entered our state constitution in 1973, which set out a constitutional established sovereign immunity, because prior to that time, sovereign immunity in Georgia had been a common law principle. And only with the change of the Constitution in 1973 did we recognize and establish as something to be embodied in the Constitution, the right of sovereign immunity of government. That provision also has recognized that the only way that sovereign immunity may be removed is by act of this body, the General Assembly. We have in several cases over the years, circumstances done so, and the one that certainly comes to mind is the State Tort Claims Act, which outlines specifically, and I think of another one we did back in my early years in the legislature, a bill that required the liability on government's use of motor vehicles. I believe in 2000, about 2 or 3. Prior to that time, as you may recall, practice law at that point, governments would be able to have their employees drive vehicles, be involved in an auto accident, and really you had nothing as far as a right to recover against the government. So I mentioned those as expressing where this General Assembly as a body said there's going to be a change and removal of sovereign immunity in certain circumstances. Now, coming forward with the Sustainable Coast case, the court gave a history and recognized that there was also precedent that the court thought it had the right to waive sovereign immunity, and they referred to the case of IBM versus Evan as being the basis for that case of that right, and that was a decision that came out back in the 90s and recognized in this case where there was a enjoining of the state because of the question about the award of a contract, and the state had been enjoined. The state Supreme Court acknowledged the ability of the courts to enjoin the state for what may be a wrongful act, but the decision in the Sustainable Coast case acknowledged that the court had been wrong, and it said IBM versus Evans unsound for 4 reasons. 1, the clear language of our Constitution authorizes only the General Assembly to waive sovereign immunity. 2, our Constitution does not provide for an exception to the General Assembly's exclusive authority to waive sovereign immunity. And 3rd, the IBM versus Evans, we mischaracterized a waiver of sovereign immunity as an exception of sovereign immunity. In 4 cases we relied on in IBM versus Evans either predate the incorporation of sovereign immunity into the state constitution or ignored the impact thereof. You can't complain about our state Supreme Court being a strict constructionist. They absolutely said, look at this thing, we've made a mistake, we're correcting that mistake, and we're going to reinstitute the fact that unless the General Assembly waives sovereign immunity, there is not a legal basis for the courts to enjoin, whether it be a state or local government, for what may be performing an unlawful act. Also, in that same vein, you have the issue of declaratory judgment, and that is where you may have a dispute regarding the rights of parties either under the contract or the interpretation of a statute, and you seek guidance from the court for the purpose of getting direction. We use declaratory judgment, and that is oftentimes used with a government body because of the question of how the rules or regulations are to be applied correctly, or whether a statute is read correctly by an agency. So with that background, and with the change that we had coming from this decision, and recognizing this constitutional change that started in 1973 and has come forward to our current Constitution through 1991 amendments, we felt, a number of us did, that there is a basis that a citizen of this state should have the ability to proceed to court and have redress before a judge with that power, which would be a Superior Court judge, to determine whether or not a state is acting improperly or unlawfully, or what is the correct interpretation of a particular rule, regulation, statute, or contractual provision. So in light of that, I have prepared what is known as 50-2150, and I'll read this out loud if I may, Mr. Chairman, because I think it will explain what we're doing. I want to emphasize that we try, in drafting this language, to really put back into place where we were prior to the Sustainable Coast case. They were not trying to broaden it any further, but as the courts recognized, it was thought that the power was there already. They have said, no, it wasn't, because this body, the General Assembly, did not waive sovereign immunity in these areas. Therefore, we are looking to establish by statute this waiver of sovereign immunity. The proposed language reads, the defense of sovereign immunity is waived as to any claim, counterclaim, cross-claim, or third-party claim brought in the course of this state by an aggrieved person, and I'll go back to that in a minute, seeking a declaratory judgment or injunctive relief against the state or any political subdivision thereof. Provided, however, that sovereign immunity is not waived as to any claim for monetary relief, attorney's fees, or expenses of litigation that are included in or related to such claim, counterclaim, cross-claim, or third-party claim. This code section shall not be construed to alter or amend any other waiver of sovereign immunity provided by law. So we address this only as to the declaratory judgment relief or injunctive relief. And we've also tried to maintain the fact that the party bringing this action has to be someone who is actually aggrieved by the conduct of that state body, whether it be the state or local governmental agency. That is the basis of what we have, Mr. Chairman, and I'll be glad to answer any questions.
All right, thank you, Mr. Chairman. Questions of the author of the bill from the members of the committee? Any questions? All right.
We had a sheet. You got the sheet?
Yes, sir. I got it. Brought it over here. If there are no questions from the author regarding the bill right now, Mr. Chairman, is there anybody else you want to call up as a witness before I move on to the sheet?
No, sir.
Okay. All right. We have a couple of people signed up today to come before us on House Bill 59. The first one I have on my list is Thomas Weaver. Mr. Weaver, if you would please come up, take the seat right there in the center. If you would please go ahead and give us your name, but I think I got it right, Thomas Weaver, and tell us where you're from, and if you're with any organization, please identify yourself.
Thank you. Thank you, Mr. Chairman. My name is Thomas Weaver. I'm from Canton, Georgia. I'm a constituent of Representative Scott Turner. I'm a private citizen. I represent myself here today before this committee. Mr. Chairman and members of the House Judiciary Committee, as a private citizen, I rise before you in support of the legislative proposal that is proffered by Representative William Woodard here regarding exempting the state from sovereign immunity protections that current statutory law and constitutional law proffer to the state. Under subsection E of paragraph 9 of section 2 of the Georgia Constitution, the Georgia Constitution in fact authorizes the Georgia General Assembly by law to exempt the state from sovereign immunity through the State Tort Claims Act, and this is exactly what this legislation would do. I think that if a private citizen enters into the state or before the courts of this state and under their constitutional right to do so and successfully litigates against a state governmental official or a local governmental unit official for any matter for which they can receive redress or remedy before the courts, I think that it would be a gross miscarriage of justice for that official at last minute to say, well, I can claim sovereign immunity, so, and the courts recognize that and render that whole entire court case for naught. I certainly couldn't, as a private citizen, claim sovereign immunity. Anyone in this room, including the two Superior Court justices present, would balk at the notion. I think that needs to level the playing field for everyone, that if anyone is successfully litigates in court, that there should be redress and grievances that should be honored. I also would ask this committee, if this committee were to move forward this legislative proposal to the full House, that before it gets there, I would ask that this committee move to amend the proposal that was read by Wendell Woodard to omit and delete that portion that exempts the state and allows the state to continue to claim sovereign immunity as against any attorney fees, court costs, or any other fees that the court would otherwise award. When this legislature in years gone by and over time has passed laws I could reference a few now, but I don't want to bore you. But when this legislature passed laws that allows a litigant to collect court costs, attorney fees, reasonable attorney fees, or any other compensatory claim or damage, for the state to be able to continue to have sovereign immunity nonetheless would render it for naught. If we're going to have a law on the books, or any series of them, that allows for a person to seek injunctive or declaratory relief through the court system, and the General Assembly has by law appropriated remedies, then private citizens such as myself and others, such as in the case that was referenced by Wendy Woodard here regarding the Department of Natural Resources, they should be able to claim all the redress and grievances that a superior court would be prepared, or a appellate court or the Supreme Court would be prepared to honor or allow. Thank you.
Thank you, Mr. Weaver. We appreciate you coming today. Any questions of Mr. Weaver? Thank you for coming today. We appreciate your participation. All right. The second person I have signed up on the list today, and I am going to try to pronounce the last name.
Sarah Garrity.
Sarah Garrity? Sarah, are you here today?
I am.
Sarah, please come forward and pronounce your name correctly if I didn't, and tell us who you are, and welcome.
You got it right. It's Sarah Garrity. I'm a lawyer at the Southern Center for Human Rights. At the Southern Center, we represent indigent people in a range of civil and criminal matters. We represent people who would otherwise not have legal representation, and in the course of our work, I'm afraid we do come across many instances in which state officials are acting outside of the scope of their legal authority or in violation of law. I'd like to speak in favor of this bill, which I think is critically important for the following reasons. As the chairman said, after Sustainable Coast, there is no way for an aggrieved citizen to go to court, to a Georgia court, and to seek injunctive relief under state law to restrain an illegal act by a government official. Second, and this is critically important, a lot of the people in the position to need such relief are often our most vulnerable citizens, children, people with disabilities, elders, people in state institutions. Third, declaratory and injunctive relief are traditional and long-used methods to ensure that governments comply with the law. This is a non-political issue. While I certainly understand the Supreme Court's reasoning and respect its application of strict construction in this matter, the fact is that the decision upends long-standing limits on governments acting in violation of state law and the state constitution. I'd highlight that this is only a waiver of sovereign immunity, of course, with respect to injunctive and declaratory relief. So this is not about money damages. As to any concern, relatedly, as to any concern about stirring up litigation or opening the floodgates to litigation, I think these concerns are unfounded. The bill is simply going to restore the law to the state that it was in February of last year. So for those reasons, we'd ask the committee to support the bill. Thank you.
Ms. Garrity, we appreciate you coming today. Any questions of the witness from the committee? Thank you so much for coming today. We appreciate your participation. I do not have anyone else signed up on our list to testify regarding this bill. Is there anyone from the audience that did not have a chance to sign up that did wish to speak to House Bill 59? Seeing none, we'll bring the bill back to the committee. Mr. Chairman, did you have any comments before
Yes,
we
I do.
move
One
on for a
last thing
motion?
I meant to mention and overlooked, and that is what is also recognized in the Sustainable Coast decision is you may not be able to sue the state or a local government, but you do have the right to sue the person who is performing the act, you might say, individually. And I don't think any of us want to have the employees of the state or local governments exposed personally to lawsuits. I know that sometimes happens. And if you ask most any person as a commissioner of a department, a director of a department, how do you feel about being sued individually? They're very much concerned about that because it has an effect upon a number of things, credit being one. It doesn't matter what the circumstances may be, your name's picked up and put into credit information and circulated in that manner, so that there's always a problem about that part of it. And that also goes back to what I was saying earlier, back before we changed the law dealing with the tort actions on automobiles with local governments. Your only recourse was to sue that driver individually. If you were hit by, say, a car owned by the city of Atlanta, you had no recourse against Atlanta, but you could sue the individual driver. We really wanted to avoid those type of circumstances, and that's one reason we changed the law back in 2002 or 3, whenever it was. So I bring that up as another purpose and justification behind what we're trying to do here. Thank you, Mr. Chairman.
All right. Any other questions of the presenter of the bill? All right. Yes, sir. Representative Mabry.
Thank you, Mr. Chairman. Quick question. Writ of mandamus, does that need to be included, or maybe the definition or a declaratory judgment takes care of it?
I think not, because you have statutorily recognized the ability from an old statute to have mandamus against public officials. That's already by statute stated.
Okay.
It's not stated as far as injunctive relief or declaratory relief.
So by statute, we've already waived it in that instance,
Yes,
one would
sir.
say. Right. Okay. Any other questions from the committee, Chairman Weldon?
With respect to that question, you have, you can get a writ, I think it's called in prohibitum, against a...
Prohibition.
Okay, thank you. That prohibits an action by the governmental agent or the government, or you can get rid of mandamus, and that requires them to do something, affirmatively do their job, right? And that's I think that's the difference.
Yeah, and those are by statute rights granted to individuals seek that relief.
Another one is quo warranto, to remove them from their office if
pro
not
warranto.
properly there.
Mm-hmm.
Yeah. Okay. Any other questions for the presenter? Mr. Chairman, go ahead.
To Chairman Willard, this would be in addition to, this would be state court or state law remedy as opposed to the federal law.
Correct. Yeah, and we had discussion about that, Mr. Weldon, and that the federal courts may not be looking at state law. If there's a action brought in federal court against a state official, they may be looking at federal constitutional law. But if they do need to apply state law, this would be the aid that they could use in recognizing that the General Assembly has provided for that type of relief.
All right. Any other questions from members of the committee before we move on? Okay. The bill is now before the committee. Is there a motion?
Do pass, Mr. Chairman.
There is a motion do pass and a second. Any discussion by committee members? Hearing none, all those in favor of do pass indicate by saying aye.
Aye.
All those opposed by no. The bill passes.
And this is also a committee substitute bill.
By committee substitute.
Yeah. All right. You'll hand it back to me. We'll finish up. Thank you, Mr. Chairman. We are through with all the bills that we had on the calendar for presentation today. If anyone has anything else we want to state before the committee, if not, we'll stand adjourned. Thank you.